This hearing of the Senate Judiciary Committee will come to order. There have been many hearings of this committee, and I've been honored to be part of them. I can't think of one more serious than this morning. We're dealing with a case of first impression before the Supreme Court and a decision which has long-lasting impact. We're dealing initially with the first criminal prosecution of a former president for action that he took during his presidency. The charges that were raised in the indictment were serious. False crimes of election fraud, fraudulent slates of electors, sham electoral election crime, sham decision on criminal investigations, and trying to persuade the vice president to fraudulently change election returns. Serious charges brought before the court. The defense of the former president is that he is immune from prosecution. It's a question which has impact way beyond this particular case and this particular issue. Nearly 2 decades ago, then Judge John Roberts came before this committee for his confirmation hearing to be Chief Justice of the Supreme Court. I asked him about the limits of the president's power. In response, he told me under oath, quote, "No man is above the law, not the president and not the Congress." During his hearing, Roberts also repeatedly emphasized the limited role of a judge, famously comparing it to an umpire calling balls and strikes. But in 2024, Chief Justice Roberts authored the opinion in Trump versus the United States, a game-changing act of judicial fiat that puts all future presidents above the law, protecting them from criminal prosecution for abusing the authority given them for personal or political gain. In plain language, the court created 3 categories of varying degrees of presidential immunity. Core presidential actions, absolute immunity. Unofficial or private actions, no immunity. Actions within the outer perimeter of official acts, presumptively immune. The decision also protects any president by preventing prosecutors from using evidence related to conduct or acts that are immune to prosecute a president for acts not protected by immunity. The court also found that the president's motives, corrupt or not, may not be questioned. So even if a president is peddling access to his office, prosecutors would find it nearly impossible to bring charges against him. As Justice Amy Coney Barrett lamented, to make sense of charges alleging a quid pro quo, the jury must be allowed to hear both the quid and the quo. And in ruling that Donald Trump is, quote, absolutely immune from prosecution for alleged conduct involving his discussions with Justice Department officials, the court has stripped the Justice Department of its critical independence. Department of Justice may now stand as a weapon to be wielded by a corrupt president against his political opponents. As the committee demonstrated in our hearing known as Subverting Justice, our report about Trump pressuring the Department of Justice to subvert the 2020 election is not a far-fetched scenario. So what does all this mean? It means that any sitting president may hide behind their office for protection from prosecution for even the most egregious forms of wrongdoing. It means effectively condoning Richard Nixon's claim that, quote, when the president does it, that means it's not illegal. In fact, most of the conduct at the heart of Nixon's Watergate scandal, the obstruction of justice, wiretapping, cover-up, and the misuse of government agencies could be described as official actions that would be presumptively immune under this court decision. The Roberts Court judicial activism has also left us with limited options when dealing with delusional or corrupt executive. During the second Trump impeachment trial, the Senate Republican leader stated, and I quote, "We have a criminal justice system in this country. We have civil litigation, and former presidents are not immune from being accountable by either one." That was a quote from the Senate Republican leader. But this is no longer the case, because the Trump versus the United States ruling demolished our justice system's ability to hold any president accountable for abuses of power. Obstructing a federal criminal investigation of your campaign by firing your Attorney General? Allowed. Steering foreign governments to your family hotels and resorts in exchange for access to the White House? Presumptively immune, and your motive cannot be questioned. Contrary to the Chief Justice's supposed goal of preventing political retribution through prosecution, he has heightened the chances of future conflict between the political branches. If faced with a corrupt presidency to meet the demands of the public and the Constitution, Congress will have to assert its power, from appropriations to oversight to legislation. The Supreme Court has made it nearly impossible for the courts to hold a runaway president accountable. It will be left to the American people and Congress to try to hold the line. Because, as Justice Sotomayor noted in her dissent, the president is now a king above the law. And with that, I turn to the ranking member Graham for his opening statement.